On behalf of Green's List, it really does give me great pleasure, and I mean it, to invite you all and welcome you all here today. My name is Paul Scanlon. I've been on the Green's List since Michael came in 1997, and it's not a time for discussing the Green's List, but with the help of Michael and in particular Brett and Luke, we've developed a powerful list of, I think, very competent barristers, excluding myself. I am quite intrigued about the topic that Bruce and Conor are going to speak about, because I find it quite staggering that questions that are put to a medical panel are subsequently, in some way, which I'm sure will be explained by them, which I've never quite understood, in some way imposes upon a judge an obligation to accept the medical panel. And questions that are asked, I learnt many, many years ago the need and the care in which one should put their questions and the order in which they should put them. And I learnt that experience many years ago, when perhaps a lot of you weren't born, when I was opposed to a very fine young lady in the Magistrates Court who our careers have followed a very similar path. She's now a Justice of the Supreme Court, and I'm running a damages trial in the Magistrates Court at the moment. The case was all about circumstance in which the vehicles came to collide, and it was to be determined by the route that each car took, because if what my client was saying was correct, then it can't have happened in the manner in which her client was alleging. And the manner in which one asks a question and the care with which one asks a question and the order in which one asks a question became apparent to me when Her Honour, as she now is, put to my client that he'd travelled north up William Street, that he'd then travelled left into Lonsdale, and I won't go into the great detail, but it was very significant about the route that had been taken. And after a series of questions of where did you go then, I turned left and then I turned right and then I did a U-turn and then I came up and back. And she went on and on about these questions. She said, now, who was in your car? And I said, Sally O'Brien. He said, yes, very well. And then she said, now, was that your normal route? And he said, no, I had lots of girlfriends. And that, I can assure, is a true story. So questions to the medical panel, I'll be very interested to hear about them as well. Bruce McKenzie, a member of our list, is seriously a personal injury specialist, a very competent barrister, and came to the bar in 1997, having been admitted in 91. And likewise, Conor O'Sullivan, who was admitted in 2007 and has been at the bar and on this list since 2010. And Bruce, you going first? And if I could now introduce Bruce to you, a fine member of our list, and he'll take us through some material which we will find, no doubt, very interesting.
Morning, everyone. Today, the overview of the issues that Conor and I are going to cover is set out in that face sheet, and in typical fashion, I'll start with my pet topic, psychiatric cases, psychiatric injury cases. As we know, they make up the bulk of the litigated claims that go before the courts. When I say litigated, that's principally the ones that can't be sent to the medical panel by virtue of their nature. As we've seen there's, for things like fights over particular medical expenses, there's a preference probably on both sides to send those off to the medical panel. But these psychiatric injury cases remain matters that have to be litigated, or at least properly prepared and each side ready to go for the purposes of running the matters. They are very much driven by what people, by human interaction, as opposed to the physical injury cases where you can establish to everyone's satisfaction what the weight of the particular object was, or the rate at which they were handled, or whatever it might be, the physical work process. Psychiatric injury cases are very fertile ground for litigation by virtue of these more subtle matters, such as people's communications with each other and their reactions to those communications and their dealings with each other. As you've probably seen, it's a subject that I like to do a talk on every couple of years, so I won't dwell on it too much, but the thing that I'd like to highlight for the purposes of today is in the context of Section 82.2a. Section 82.2a has been revamped, as I've set out in the paper, and it applies to claims lodged on or after 5 April 2010. Now, we're 3+ years down the track. You'd think that most of the claims that were on foot have been brought to bear by now and through the system by now. There's always the prospect of some of the older ones hanging around, but in real terms it seems that we're dealing with the post-5 April 2010 world. I've set out the legislation, that's well-trodden ground. What is interesting in this, in more recent times, is the change in attitude, or certainly the perception of a change in attitude of the bench to dealing with the issue of reasonable. Reasonable has been considered by a couple of the courts recently. I've set the decisions out in the paper. First in time is His Honour Judge Parish in the matter of Rogers. He usefully referred to some of the authorities coming out of New South Wales, and he's emphasised that a course of conduct may be reasonable even though particular steps are not reasonable, and he uses the expression blemishes. It makes sense when you think about it. It's not an absolute standard, it's a reasonable standard, and the good thing about it for the lawyers is that everyone's got a different idea of what reasonable means. In a particular case, there's all sorts of variables, as we've seen. It's hard to extract from the cases a set of definitive or criteria or a definitive checklist that you can just work your way through. Again, that's something that is probably a topic for another day, but it comes down to very much what's reasonable, and it's reasonable in the particular context, so that what was reasonable in case A might not be reasonable in case B, and that's why you always need to look at the particular circumstances of your individual case. And it's been followed up, that idea of reasonableness has been followed up by Magistrate Garnett. He's provided he seems to be providing most of the judgments that have gone to conclusion on this issue, and he's dealt with it in the case of Kriegsman Yates, as I've set out there. The interesting thing again about that is the section that I've underlined. He's adopted the views that are expressed by His Honour Judge Parish. He's also spelled out that the judgment required in applying the section is whether the thing was done reasonably, and not whether it could have been done more reasonably or in a different way, more acceptable to the particular court. He's followed up on that more recently in a case of Treacy and Western Health, and again I've set out a reasonably helpful quotation from that case. That was a case where the plaintiff, where the Section 82.2a defence was successfully applied by the defendant, and His Honour emphasised in that, he's referred back to the previous matters, but he's also emphasised that it comes down to a matter of looking at it in a global context, so that again what works for or against the worker in case A doesn't necessarily work for or against the worker in case B, and it's very much a case of looking at the particular circumstances. And it's interestingly, that section that I've quoted there, or that passage I've quoted there, refers not to things viewed objectively, and not with the benefit of hindsight. So again, it's a matter of looking at it more objectively, and also it's a matter of looking at it with the prism of what is objectively reasonable, perhaps. So there's a subjective content to it, or subjective element to it, in the sense of look at the particular facts, but then in terms of what's reasonable, you look at it more objectively, and as opposed to how a particular worker might have reacted to that particular management action. And we all know management action goes on forever, the definition of that. But it comes down to that idea. So there's more of an objective element perhaps coming into the analysis. It remains to be seen how far that goes, but it perhaps mirrors what goes on in some of the psychiatric injury cases, in the sense of the analysis of things more objectively, rather than the particular mindset of the particular worker. Now, the next topic that I'd seek to deal with is Shin Estoppel. Shin Estoppel is a type of estoppel, and it comes out of a decision of Port of Melbourne Authority and Shin Proprietary Limited. It ended up in the High Court, and the principle, it takes a while to say the principle in the judgment. There's no neat passage that I could quote, but essentially what it comes down to is putting all of your case forward. Now, if you're the plaintiff, that means putting all of your causes of action forward. If you're the defendant, that means putting all of your defences forward. And in the context of compensation claims, it's important to make sure that when you issue proceedings, you bring as much of the proceeding to bear as you can. It was recently illustrated in the matter of Stankovic and Steelfield, and it had a somewhat unfortunate history for the following reasons. The matter was brought on for what you might consider to be fairly garden variety physical injuries. He's a process worker with physical injuries and a secondary psychiatric injury. That was how the case was, that was what the original claim was for, that was how the proceedings were commenced, and shortly prior to the hearing, a report drifted in from a medico-legal psychiatrist highlighting potential primary psychiatric factors, potential primary psychiatric injury, based on, amongst other things, redundancy and the way the worker's redundancy was handled. Now, we all know that that sort of redundancy, primary psychiatric injury, quite often forms the basis for its own claim, its own proceeding. What occurred in Stankovic's case was that at the commencement of the hearing, counsel for the plaintiff had realised this, raised it with the bench, and asked that the matter be adjourned effectively. The bench, when you read the transcript, you can see that there was a fair bit of byplay on this issue, but what it came down to was the counsel for the plaintiff had identified the issue, had identified the potential Shin problem, in the sense that if the worker did not bring the primary psychiatric injury case as part of the case that was about to be litigated, the defendant would run an Shin, or could well run an Shin Estoppel defence and say, well, you should have done it all in the one go. And the policy for the Shin Estoppel idea is obvious. The court's clogged enough as it is with claims, and no one wants to be running them again if we can avoid it. It's in the interests of everyone if we can do these things once and for all. Unfortunately, at the time of the Stankovic's original hearing, Aon risk was very much the flavour of the month, and you might recall when the Aon decision came out, achieving or obtaining adjournments that you might readily have achieved a week or two before, post Aon risk, were very problematic, and everyone was referring to the scarcity of court resources and the need to have public confidence in the system and so on. There was very much a backlash against the adjournment proposition generally. And that seems to be why the adjournment wasn't ultimately allowed. It was refused on Aon risk grounds. Now, Aon risk grounds, for those of us who practice in compensation, will know that Aon has fallen away as a factor. In other jurisdictions it may get more force, but the view in the compensation jurisdiction is very much that workers should have their chance to put their best foot forward in terms of a case, and they should be given every opportunity to do so. And for those of us who practice in the area, we know that it's high volume, we know that things get missed, we know that, as in Mr Stankovic's case, in the hurly-burly of dealing with the physical case, the psychiatric case perhaps didn't get the attention it deserved. It was picked up, and counsel for the plaintiff appropriately tried to bring it to the attention of the court, but it was refused by the court, that leave. Mr Stankovic did reasonably poorly on one view in relation to the primary physical case, came back again for the primary psychiatric case, and the defendant argued an Shin Estoppel point, and His Honour Magistrate Wright had to deal with that. And I've set out the passages that in the paper where he deals with that. It's noted that the Shin Estoppel point has only been ventilated, or successfully argued, I should say, in a couple of workers' compensation decisions, and through all the scouring that went on, only two of them came to bear. One of them is O'Flaherty. That's a decision of Judge Anderson of the County Court of Victoria. O'Flaherty was a shearer who ran his case based on injury under Section 82(1), the normal sort of injury definition, and then having been unsuccessful there, he came back and tried to run it as a gradual process injury under 82 subsection 6, and the court held that that ran foul of Anshin. Now, Anshin in practice for the compensation area is one that can be argued, but there's a reluctance on the part of the courts to apply it. I've tried to argue it in the context of a common law proceeding for various injuries A, B, C, and those injuries, and then the workers come back with a compensation proceeding based on those injuries plus a few more, and it's those few more injuries that are the real substance of the case. I've argued that unsuccessfully, and the court's taken the view that you look at the considerations involved, and that's what His Honour Magistrate Wright's referring to in that passage from paragraph 51 that I was referring to. There's different considerations in, say, a negligence claim where you might have, as we all know, you can have good injury, poor negligence, and vice versa, good negligence, poor injury. So those sorts of motivating factors are accepted as being legitimate reasons why you might not push all of your injuries in the context of the common law claim. And for that reason, there's a general reluctance to apply Shin Estoppel, but the important thing out of Stankovic is that His Honour did highlight that it remains valid, and in the appropriate case it will be used. So the message for all of us is to do the best we can to be alive to the various potential causes of action that we have and bring them forward. The typical way I think that we can fall foul of this is to not include particular injuries. Generally, the cause of action is, there's only a limited scope for whether you bring it under Section 82(1), Section 82(6), Section 86(1), whatever it might be, injury or disease. That part of it's fairly straightforward. What you can run into difficulty with is if you don't bring in a particular injury and then try and rely on that at a later stage. The argument will be, look, you should have known. Again, you should have brought it forward. You can argue that you didn't have to bring it forward if it wasn't known, or if the connection to employment wasn't in any way known. That's a different matter. But the primary position would seem to be, when in doubt, try to bring all of it together in the one go. Then, return to work is an area that, again, seems to take up a bit of time. Return to work used to be sudden death. The return to work termination notice used to be a once and for all proposition, and once served with a notice, if the notice was upheld, then no matter how good your injury might be, your entitlement to weekly payments of compensation ceased and determined because you hadn't made reasonable efforts to return to work, cooperate with rehabilitation and so on. It's been changed, and post 5 April 2010, again, you'd think that most of the old return to work cases are through the system by now, so that we're dealing with the new regime. The new regime has recently been considered by Magistrate Garnett in Kavanagh and SRA. I've set out the way His Honour has analysed the provisions, and it's a handy little summary as to the stages. And the essential change is that instead of it being a one-stage, one-shot proposition, there's a couple of there's staging in the process. There's a warning, there's suspension of payments, there's termination of payments, and then finally there's the cease and determine proposition. There's been some useful matters put forward by His Honour in that Kavanagh decision as to how you consider and the things you consider when you're looking at whether or not someone's made a reasonable effort. And he's listed those factors. He's drawn them from a number of the cases, a number of the prior cases, but it's a handy checklist for both sides of the fence to look at in terms of assessing these matters. You look at the injury, you look at the incapacity, you look at other factors that might impact. You look at medications, whether they make them drowsy, whether they make the worker drowsy, that sort of thing. The opinions of treating practitioners. I'll just pause there. The earlier decision that His Honour referred to, the decision of Justice Osborne in Rangelovic, was one where His Honour emphasised that acting on the advice of a treating practitioner is, I suppose, highly persuasive but not determinative. So the fact that the client has been acting on the advice of the GP goes a long way to satisfying the requirements, but it's not determinative. And he goes on to emphasise other matters such as place of residence, where they have to go. For example, if there's a restriction on driving, but the offer of employment requires a prolonged period of driving at each end of the period, that's going to be a matter that's taken into account. Kavanagh was also useful for both sides to look at because in Kavanagh's case, the worker had a long history of bad blood with the employer. Now, on a reading of the case, it seems to have started with the employer. The employer done him wrong in relation to weekly payments over time, and it caused some difficulty between the two. It caused the worker some difficulty, it seems, by erratic payments or passing on of payments and that sort of thing. So all of that may be true, all of that may be valid, but when it comes down to this analysis, the fact that the worker won't cooperate with that bloke or that person is a problem. And in Mr Kavanagh's case, it was a problem for him because the court found that that was the essential stumbling block. Now, again, always, as with the psychiatric injury cases, forewarned is forearmed. If you can get hold of the clinical records, have a look through them. There are often comments made by the worker to the treating practitioners, particularly GPs and particularly psychologists, as to what their motivations are, and those matters will be picked up and will be explored. So if you can look at those matters, again, both sides of the case, each side should be looking at those issues to see what the motivations, underlying motivations, if any, might be in a particular case. The other thing that I throw in is also to get some medical opinion on the return to work proposition itself. It's less of a problem than it used to be, but so often you'd turn up to court to fight a return to work case and you had generic medical reports dealing with generic descriptions of injury, generic descriptions of capacity. No one, and often on either side, but had obtained medical material that actually dealt with the issue. That is, was this particular return to work plan at that time suitable? And the case rises or falls on that issue. Conciliations have been a leftover or a source of some difficulty, and they've caused many an adjournment over time. The problem's been alleviated a bit, but it's again something that we all need to turn our minds to, particularly on the workers' side of the fence, to make sure that the show's ready to go when it comes to the hearing. For everything except death claims and the old Section 98 Table of Names claims, pre-12 November 1997 injuries, you need to have gone to a conciliation. So no matter what the dispute is, you need that conciliation certificate. The policy behind it is that it enables, if not resolution of the issues, it at least clarifies the issues. That's the theory behind it. I don't know statistically how many cases settle at conciliation, but it's something that's worth exploring in every case. The problem used to be that you'd turn up to court to fight a weekly payments case, and there was an issue about proposed surgery or an issue about some form of medical expense or a wide variety of different other issues that you wanted to ventilate, you wanted to get dealt with as part of this proceeding to avoid any anshin problem, but you couldn't because you didn't have the conciliation certificate. Section 49(1)A enables the court to dispense with that requirement in relation to this, what's called the other dispute, and the sort of factors that are taken into account in the exercise of that discretion are set out in the Cortez decision that I've set out in the paper, and really they're fairly self-evident, and it's a handy common sense checklist of things to look at. Amongst other things, it's helpful if there's notice given to the other side, and while it might be said that particularly defendants are acting as agents or acting on behalf of the agents, the insurers of the Victorian WorkCover Authority, for example, as we all know, the processes of communication might not be all they can be in relation to this. So if you find an issue, communicate with the other side, and often can be sorted out. It comes back to whether the issue's related to the particular subject matter. It doesn't have to be directly related, but one thing it needs to be is something that's not a fresh claim. Now, in the case of Fordham, in Mr Fordham's case, it was a case involving a foot injury and in the context of amendments to the proceedings, the plaintiff tried to ventilate a back injury, and there'd been no claim made. So in the case of an injury, you always need to make the claim. That's the foundation for the jurisdiction. And the other case I've referred to as a matter of Stitt, where there'd just been no conciliation, there was a conciliation certificate in relation to an old issue, and the issue that was the subject matter of this proceeding hadn't been to conciliation at all. There's some of the things that have come out of the cases in the last 12 to 18 months. Thanks very much.